all the words in the Minister's referral motion appearing after the word committee be deleted. Sir, on that issue, there's simply no justification for a referral motion that was phrased in the terms that the Minister read out in her prepared speech. If what the Minister has foreshadowed on behalf of the Minister for Justice is that we're in for yet more meaningless urgency on bills that don't merit it, then members on this side of the House protest greatly about that, and I think other members ought to be concerned as well, because it is an abuse of the processes of this House to deal with issues as serious as the ones that we're dealing with in this session under urgency without proper justification. And although the Minister clearly foreshadowed the use of urgency, she didn't deign to tell the House why there might be the need for urgency in respect of a bill like this or in respect of other bills for the rest of the year between now and the foreshadowed deadline for reporting back. Well, and Mr Quinn has interjected with one of his learned interjections again. He says the taxpayers want us to work. Some members on this side of the House work pretty hard, Mr Quinn. We're prepared to do that without the need. All members on this side, some members of the House, all on this side of the House, and we don't need an urgency motion to tell us that that's what we should be doing. It would be helpful if members on that side actually worked out that doing the business of this House properly didn't involve urgency, but involved the consideration of legislation. But that's something they seem to have forgotten, because this House, under this government, is using urgency more often than any other government for many, many years. It's just not justified. Look at the program. There's no justification for it. It's an outrage, especially when we should be doing our job. And the taxpayer is not going to thank you, Mr Quinn, if we're back here in a year's time amending shoddy legislation that's been rammed through this House under urgency. And mark my words, if you continue as you are on that side of the House, members, then that is what you will see. Mr Quinn says the opposition agreed to the motion. I can tell him and his colleagues there will be no more agreement to such motions if the sort of motion we've seen from the Minister who's just spoken continues. Now, sir, the Minister in her prepared speech that she read out referred to the report of Dame Margaret Baisley. And there were some aspects of that report that are worth having a good look at. It found that there were some serious problems with the current system that was set up in 1991 by the former National Government when this Parliament passed the Legal Services Act 1991, merging the former civil and criminal justice legal aid schemes. And there are some members opposite who know a lot about the detail of this. I look at Mr Burrows in particular. It would be interesting to hear his contribution on this. But clearly there are some problems with the current system. There are problems in defining the respective relationship between the Legal Services Agency and the Law Society. It's been suggested in the report and elsewhere that the fact that the legal profession asserts control over the legal aid system through the Law Society creates a real risk of there being no independent oversight. Even though the Legal Services Agency can at the moment provide some oversight, it doesn't have the necessary means in all cases, it is said, to remove legal aid providers who are found to be performing poorly. And probably the other salient structural criticism in the report is that there was some highlighting of how legislation makes the market for legal aid arguably more inefficient than it needs to be. And one of the instances that was cited in the report is that the current law has inflexible provisions for procurement which make the Legal Services Agency's processes overly bureaucratic, stop it from procuring services in the most efficient way. An example is the flexibility to choose between a public defence service, a community law centre and legal aid. That ought to be an easy choice for somebody in need of legal representation. And when public money is at hand, one would think there would be room for the relevant authorities to use it as efficiently as possible. Dame Margaret's report made a series of other recommendations, and these included raising the barriers to entry so that it was absolutely clear that lawyers working in the legal aid area were absolutely competent and equipped with the requisite integrity to do so. That's obviously something nobody could argue with. It's been recommended that there be a mechanism put in place for the swift ejection of lawyers who don't satisfy those criteria. There's a recommendation that there be clarification on the regulatory side as between the legal services authorities and the New Zealand Law Society, and there be an option to use publicly funded services like the Public Defence Service when they're the most efficient option on the table, something that isn't available under the current arrangements and ought to be. And it's good to see some of those matters picked up in the version of the bill that's been tabled for first reading. There are some important changes to the administration of legal services intended. The administration of publicly funded services is to be transferred from the Legal Services Agency to the Ministry of Justice. Similarly, the Legal Aid Review Panel will be disbanded, its function to be carried out by a Legal Aid Tribunal within the Ministry of Justice. And there's to be the position of Legal Aid Commissioner created to have an oversight of the operation of the system, an independent eye cast over the legal aid system to make it all accountable. So Labor will support this bill to a select committee because those are, as far as we can tell, good recommendations, and the bill does implement some good and sound policy. But we do have some concerns. The first I've already dealt with, the fact that we're dealing with this legislation under urgency, and the Minister's clearly foreshadowing that the government intends further unmerited urgency throughout the year. But the second relates to the Minister's conduct in the wake of receipt of Dame Margaret's report and some of the allegations made. And I know that my colleague Leanne Dalzell dealt with this publicly at the time. She and I also went up to meet members of the Manukau Bar, many of whom do rely in part, or actually in large part in some cases, on legal aid to provide access to justice for their clients. And I have to say they are by and large, in fact by overwhelming majority, reputable lawyers who work hard in unforgiving situations to provide access to justice when it's needed to ordinary New Zealanders. And they are to be praised for the hard work and the dedication and the integrity that they exhibit. Unfortunately, there were some obviously quite inaccurate allegations in Dame Margaret's report. She said that up to 80% of the bar may be abusing the legal system out at Manukau. Well, clearly that's not right. We've met many of those providers, and as I say, they are good people who deserve better than that sort of allegation. They deserved, I think, for Simon Power to have refuted that allegation rather than simply accepting the report that he did, because surely the principles of fairness would have required that. We have some other concerns about the substance of the bill. The area of legal aid and employment disputes, I think, needs further attention. And frankly, we have some misgivings about whether or not the wider aims of the bill will be able to be achieved in the wider context of other legislation already passed in this Parliament in this session. If the whole purpose of the bill is to curb the out-of-control cost of legal aid in New Zealand, as it's alleged exists, this is particularly high in the criminal area. But the government can't, on the one hand, try to achieve that and then on the other pass the completely misguided three strikes legislation, which will work directly against that objective. Because of the higher prison sentences, which judges will have no option but to bestow in criminal cases under that legislation, not guilty pleas have been positively incentivised. This will inevitably lead to the prolonging of trials, place extra cost pressure on the justice system. If the government had any regard for proper policies working comprehensively, let alone fairness, then that would have been looked at rather than this piecemeal approach being adopted. So, sir, we do place real value on having a well-functioning legal aid system. It is essential that everybody has proper access to justice and that be one of the rights that is guaranteed by the state. So we will support the bill going to select committee, but we do have the reservations that I've stated in this speech.
Members, the question is that the amendment be agreed to. Chester Borrows.